Okay, this is Dr. Bechtel, and I'm going to do a two-part series of videos, ethics videos. And this first, get this going here. We're going to cover in these two videos confidentiality and attorney-client privilege, which is a fairly short subject, so I'm combining with that conflict of interest, which is a little bit longer. And then the last video, the second video, will be on unauthorized practice of law. First, we're going to look at the confidentiality, but before we do that, I want to give a brief history of the ethical rules that legal professionals are subject to and their history. The formulation of some ethical principles took place initially with the American Bar Association in early 1908, and these were general statements of these principles that require proper conduct of lawyers. And keep in mind that the American Bar Association, ABA, doesn't have disciplinary authority. What they are is, if you will, an advisement source for all of American lawyers and law firms and other stakeholders in the professions. What they do is create rules that that look like, and the states basically adopt the rules from the ABA. So they set a standard, and the states go in and build out their own based on their standards. Think of it like a template. Here's a template of what it could look like. States, you all go right ahead and take our advice, if you will, where you will, and as you will. The history also includes the 1970 principles that were more crystallized when the ABA created the model code of professional responsibility. And that word model really does help to understand what I pointed out in the previous slide about here's a template. Well, I should have thought of the word model. That's a better word because that's what they use. Help you remember. And the states quickly came along and adopted what the ABA had set forth in the 1970 version. The ABA also developed a multi-state bar examination, and because the states all had their own ethics portion of the multi-state bar, of the bar exam, and this allowed this opportunity to kind of go with the flow of the ABA, given that the model code of professional responsibility had been adopted so highly in the states. Why not have a multi-state bar exam? In 1983, they studied more about the model code and reformulated it, and they called this reformulation the model rules of professional conduct. So now let's compare these two, the model code versus the model rules. Each of these models they address the same issues. Some comparison does show a difference between the two, because the canons are written more like thou shalt not, and it's designed as a code to live by. Thou shalt not. Model rules, on the other hand, are more sophisticated. They outline, they set forth more language, like legislation would do, and we talk about the legislative actions and how they promulgate rules later in the course. But for now, recognize these are the chief differences. Legal assistants, paralegals, are also in need of ethical guidance, and codes for legal assistants have been created, and these are created by legal assistant organizations like National Association of Legal Assistants, National Federation of Paralegals, and there are no disciplinary or sanctioned type of problems that develop necessarily, but of course, if you break a code and someone reports it and there's any investigation, which I don't know what NALA or NIFPA do when they get a report. But they can take away your stripes, such as your certified paralegal designation. That would be NALA that can do that, and basically kick you out of their club. So they want you, if you're going to take on the name certified paralegal, by testing and showing your knowledge and ability to serve as a paralegal, they're also obviously want you to follow their guidances as far as ethics are concerned. So, as I was pointing out, National Association of Legal Assistants, NALA, drafted their first code of ethics and professional responsibility for the specific use by paralegals in 1975. And their most recent revision, probably later than that, I'll bet, because this might be an old slide from a previous presentation. I'm pretty sure it is. And it's composed of 9 canons, and they resemble the model ABA code of professional responsibility. It does have a high concentration on the unauthorized practice of law, just simply out of necessity to continue to inform non-lawyers to avoid practicing law. Confidentiality really comes after giving you that history. We'll go into confidentiality. Confidentiality stems from 2 frameworks. One is ethical rules, those that prohibit attorneys and paralegals from disclosing information regarding a client or a client's case. And the other being rules of evidence, and specifically attorney-client privilege, and that is a specific legislation that prevents an attorney or paralegal from being compelled to testify about confidential client information. Understand that attorney-client privilege is a subset of confidentiality. And so we'll look at these 2 in relation to each other. As you can see, under the model code, the ethical rules regarding confidentiality, under the model code, it's going to apply to confidences and secrets supplied by the client. And this word confidences is sort of strangely tucked in with secrets. It's the same thing. I mean, I did a little bit of searching to see if we could really find what's the difference. It's just a matter of using two different language concepts. They're learned from any source, so confidences and secrets learned from any source regarding anything and made anywhere. So these you would call elements right here. On the other hand, under the model rules, they apply simply to information relating to the representation of the client. These are so intertwined, but as you can see, if all the conditions are present, the attorney or paralegal may not voluntarily reveal information. However, under the confidentiality in the ethical rules, it's going to point out that they don't have to, but they can, but they may still be compelled to testify unless this result is found in the conditions of it being under the statutory attorney-client privilege, the rules relating to trial practice. And it's going to apply to client statement, to an attorney or paralegal, made while seeking legal advice, and given in confidence with no unnecessary persons present. This is one of those essential things. A lawyer will have an initial consultation with a client, and when the client brings a friend, a family, someone else with them, care needs to be taken that confidential confidences and secrets, if you will, statements made by the client, clients there for a consultation, could erase the confidential nature of the communication. And if any of these 4 conditions is missing, so we're looking for 1, 2, 3, and 4, just like you see over here, and this is an important word. It means that all these things must exist. So if any of these 4 conditions is missing, the attorney can be compelled to testify. So that settles what is the necessities of confidentiality. We'll move on now to conflict of interest. And conflict of interest is the ethical rule prohibiting attorneys and paralegals from working for opposing sides in a case. There are more than one sort of scenario that might come up with conflict of interest. We might have a personal conflict. We may be in a situation where the attorney is in concurrent representation, and that can create an actual conflict. Concurrent representation also with the scenario, depending on the scenario, could create a potential conflict. And we're going to look at some examples of that. Successive representation is also possible, and so is vicarious representation. So let's look at these individually. Where there's a personal conflict that may bring about a conflict of interest is in this example where a husband and wife are represented in opposing sides at litigation. Now, we're talking about who is representing the clients or representing the parties in the case. So we have a store customer in this example, and the store customer is suing a grocery store. Slip and fall happened, or whatever the case may be. It's a negligence case. And the attorney representing the store customer is Mr. Abbott. So Mr. Abbott's going to receive 33% if he wins. So he has got some skin in the game if he wins on this negligence claim against the grocery store. Well, it just so happens that Mr. Abbott's wife, Mrs. Abbott, is involved with the grocery store, the defendant in the case. So the plaintiff's attorney and the defendant's attorney, they're married, they're a couple. And that means, and in the grocery store's case, it's not a contingent fee. In other words, there's no percent of the winning because there's nothing for the grocery store to win. Well, I won't go into anything complicated here, but the grocery store is going to be represented on an hourly fee basis by an attorney. Just so happens in this scenario, Mrs. Abbott is the attorney. Well, either way, she's going to win. And 33% of Mr.'s winnings of the store customer's winnings could be in the hands of Mr. Abbott. And so that's a problem because she's going to receive a fee. The Mrs. representing the grocery store is billing hourly and going to receive a fee no matter what the outcome is. And the store, as in her client, might question whether Mrs. Abbott could really represent the grocery store zealously when Mr. Abbott already has a personal stake in the outcome, as well as her. Another form of a conflict of interest is concurrent representation, where there's an actual conflict. When we have concurrent representation, what we're talking about is we cannot represent both parties. In this situation, we have Deb Driver, who's represented by Attorney Baker. Well, Deb Driver is the plaintiff. That's what this little code here means. I didn't say that in the first slide. And this little triangle is defendant, Tracy Trucker. So Deb Driver has been injured in a car accident, presumably caused by Tracy Trucker. And so how can Attorney Baker represent both sides zealously? It can't be done. We also have situations where there's concurrent representation in a potential conflict. So on the face of this scenario where Deb Driver and a passenger of Deb's car are going to be represented by Attorney Baker, and they're wanting to sue Tracy Trucker. The problem that could come up is that, and so this is the potential conflict problem, is that the truck driver might, let's say the lawsuit goes out, but Tracy Trucker countersues Deb. We learn more about countersuits, but that's basically later in the course, but basically where then Tracy Trucker would say, no, Deb is also responsible contributorily negligent as well. So part of the blame is on Deb Driver. That reduces the, well, I won't go there. But before the attorney can represent both clients, he'll need to disclose that it's possible that this other driver might get countersued by the defendant, Tracy Trucker. And then we have a situation where if the jury finds both Deb Driver and Tracy Trucker at fault, Patty's actually not in the same boat as Deb. And so we have a client, we need to get client consent. And most attorneys would turn down representing everybody. And, well, I won't say most attorneys, I don't know. But they would look at the facts of the situation. Is there, you know, some analysis that might show that Deb Driver is also responsible. We also have the conflict of interest with successive representation. So in a scenario like this one, the prior representation of Attorney Smith. So Attorney Smith represented Mr. Brown, who was the plaintiff, against the defendant, Mrs. Brown, who was it was a divorce action. So Attorney Smith represented Mr. Brown in that case. Now, Mr. Brown's business partner is coming in asking for representation from Attorney Smith. So Mr. Brown's business partner would be a plaintiff in this scenario. He's described as, or Mr. Brown's business partner, he or she described as a plaintiff, and it's against Mr. Brown. So we have definitely got a problem here where we have successive representation. It would not be allowed if the two matters are substantially related. But if they're not, it may not be a conflict of interest at all. The attorney would need to decide if, one example I think would be helpful to think about here in this case is Mr. Brown was in business. Maybe Mr. Brown was in business at the time of the divorce action was taking place. Maybe there was some information or whatever shared in the divorce case that might point to Mr. Brown. Maybe there was a fight over the business ownership or a financial interest in the business. Maybe Mrs. Brown had claimed she had a financial interest of Mr. Brown's business. And so there was discovery. A lot of stuff unfolded as far as even the partnership of Mr. Brown's. And in that case, it would probably be a danger to take this representation of Mr. Brown's business partner. It would just need to be looked at from a careful eyeball on it and make sure that that may not happen. So I think this is our last slide of the confidentiality and conflict of interest topics and ethics. I will also share the references for this presentation. When I showed you the those little graphs and charts, I got those from a book we used to use in this class, Currier and Eimerman's book, Introduction to Paralegal Studies, A Critical Thinking Approach. And also the slides, all in the content of them, stem from the Pyle and Bast book, Foundations of Law, Cases, Commentary, and Ethics. So this concludes this